Nice. All right, we're back. PJ, you there? PJ is not there
I
yet.
am. I'm here.
Ah, yes, there. All right. Why don't we jump to the next slide, and why don't you jump in and talk for a minute?
Language of the code. So defined in the code, and that's defined in the DMV code or the state law codes, things of that nature. The terms of driver, license, vehicle. One of the ones that I'm struggling with, I'll tell you personally, it's an interesting thing because we talk about the vehicle, the difference between the vehicle and the car. This is a good example. Car is actually defined in the code and at law as a consumer good. There's some interesting things that we want you to look up. And when you look these words up, we ask that you look these words up 5 to 10 times in different areas. Look them up in the state statutes. Look them up in the DMV code. Look them up in a Black's Law fourth or even a third or a second. We've found definitions that are dramatically different in Black's Law second than in Black's Law fourth. And they are the differences that we're looking for to represent our rights. You may have to go back that far in time historically to see the distinguishing points of when we were operating under a right to travel under natural law and when there were certain codes that were being implemented by franchises that were being created by public trusts such as cities, states, other organizations that created these privileges and these exemptions, these liberties, and began to charge individuals should they choose to violate those rules. And we'll get into a lot of case law that talks a bit about that, about how there was at one time quite a bit of a spat between states and cities that were implementing these driving codes where they needed to have some form of permit in order to travel through their roads, so to speak, quote unquote. They travel through their city, they would need a certain permit. And there is standing Supreme Court case precedences that prove that there is no statute that can subrogate the right of travel.
Selim writes a vehicle is a device for moving something from one place to another. Not sure where she's getting that. It might be Black's Law, but it's very, very similar to what you'll find in the California Motor Vehicle Code. You got to look deeper than that because a vehicle comes from. Okay, she says it's just something that comes off the top of my head. Yeah, it's what we've been conditioned to believe is the right definition for it. Okay, let's pull up 18 USC section 31, section 6 I believe is the start at 6 and 10 are the really relevant parts. Definitions. Motor vehicle. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation of passengers and property or cargo. Commercial purposes is where motor vehicle comes from, and that's current law. Okay, federal.
It does not say that it is every description of a carriage or contrivance propelled or drawn on the highways in the transportation of passengers. It says specifically and used, and we have to be clear on the interpretation of these definitions. And used for commercial purposes means that there is a distinction of private transportation of passengers, property, or cargo. There is such a thing because it's stating here that a motor vehicle is described as every description of a carriage or contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation. So they're describing things that we inherently do. We transport passengers and property and cargo. We do that all the time. But if you're in a motor vehicle, normally that's going to be used for commercial purposes on the highway, in the transportation, in doing the same things that we do inherently. So the interpretation of that definition is really key. How it's said is really interesting. So.
Yeah, get this. This is dmv.ca.gov, an always reliable source for definitions. Vehicle Code Section 670, vehicle. A vehicle is a device by which any person or property may be propelled, moved, or drawn upon a highway, excepting a device moved exclusively by human power or used exclusively upon stationary rails or tracks. So it's not a bicycle, it's not a train, but it's anything else that might propel a person or property upon a highway. It's a result of a continual bastardization of the term over time. it's the state of California simplifying it so that you believe you need a driver's license.
It has right here in Station 10, used for commercial purposes. The term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or any other consideration, or directly or indirectly in connection with any business or undertaking intending profit. I mean, they just define it clear as day that they are not talking about private transportation.
Right. And even that, who cares? Because even that is still just code. And if we're talking about rights, then we're talking about common rights, we're talking about common law, and we can look at the court cases, and we will today, that clearly show that the California state definition of it is bogus. We applied for the driver's license, and that was our own free will, and etc. However, the colorable use of language that helped us think that that was the right thing to do is at issue. WD raises a great point, and he says, "No, fellows, I don't think you're right about your right to due process being violated by your choosing to give away a right for a privilege. Since you are the moving party in contracting the state for a driver's license, would it not make as much sense for the state to require a notice from you that you're choosing to operate in commerce of your free will?"
Very well said.
Yeah, I can't argue with you.
Very well said. We're going to cover that. You're touching on things that we're going to get into in the future.
And it goes back to the same point I tried to make earlier, and I don't know if I did. And that is that, I think the wrong way to go about, well, there's judgment. I try to avoid judgment. I think the path of accusing or stating that we were wronged in some way, or that there's some they that snowed us or whatever, and it is wrong. It's standing on your rights is about full accountability. It starts there. Okay, whatever the condition is, we did it. Okay, and whatever situation we are driving or traveling in now is our own doing. And I completely agree with WD on that. There's no reason to point a finger, but we can learn to operate in a better way. All right, so these terms, let's go back to the terms. Language of rights versus language of the code was the previous page, and we'll put up these terms. If you're not in a position to write them down, that's fine. We'll put up these terms in the Red Library for the homework for next, a part of the homework for next session. So don't worry about that. But again, these are the terms to define and understand, and look at how these cover the same things, sort of, right? But they cover them in a different language. And one of the keys to being successful in operating as a right under your right to travel is going to be distinguishing in language, because language is one of the ways that control is achieved. Okay, language is a deceptive tool for control, and to understand the difference between passengers and guests, between vehicle or motor vehicle and car and automobile. I did have on this list at one point vessel, but actually vessel just comes from UCC for the most part. I mean, the term vessel means something greater, but I pulled it off this list. You want a clean list of ways that you talk about your rights, and you'll notice that these things really don't come up in the code. There's a reason that these terms are not really used in the code. You might see property, you might see
I've seen
non-commercial in a
car.
different application.
I've seen car, and it's literally defined as a consumer good, something separate of what a vehicle is.
Oh, yeah, right. If it does come up, it's either in a different application, like non-commercial, for example. You want a little giggle, go look up how to get a non-commercial driver's license in California and what that means. It means you're getting a fifth wheel trailer or a 45-foot RV. You know, you need a special license for that because it requires you to be able to show that you can safely move that down the highway, right? But that's their idea of non-commercial driver's license. Okay, so yeah, look up all these terms. If you have any questions or want to raise any conversation about them in the next session, we'll be open to that for sure.
And we will be covering these terms as we go on further. We have 3 other series that are pretty much encompassing a fair amount of these terms and others just like them to make the distinguishing points and to make the distinctions that we're needing.
Selim says California statutes do specifically say the vehicle codes are for commercial regulation of the roads, but you have to look in the statutes, which means a visit to the law library. It does not say that in the codes, of course, and that's a huge life lesson right there. If you are approaching whatever situation in court or whatever that you may have in life, and you're only looking at the codes, you're missing the true picture because you can stand on statute. The codes are public dissemination of the statute, right? And so when the statute says something different, the statute overrides, and it's quite often that the discrepancies between the code and the statute are where the colorable persuasion occurs. And if you don't understand the word colorable, look that one up.
Very nice. Ooh, case law.
Yeah, we wanted to start you guys off on homework with a lot of it. The process of shepherdizing is to confirm all the case sightings and also confirm that they have not been overturned by subsequent rulings.
There's a good chance that we might be able to do some of that.
Okay, great. And if we can provide that for our members, we will. Eventually, we will. It is my belief that the case law that we're working with here is fine to use. And there's so much of it that I just don't know how it could all have been overturned.
Do you suggest that you do your due diligence if you're going to present these so as to not have a weak case if you were to bring these to any court? So
Right. Yep.
do your due diligence. Very important.
Yep. There's a couple on here, and then we're going to go through a lot more because we're going to go through some of that brief that we gave out as homework. But let's start with the first one here. The right to travel is part of the liberty of which a citizen cannot be deprived without due process of law under the Fifth Amendment. This right was emerging as early as the Magna Carta. Kent v. Dulles. And
Now
then,
that's fairly recent, by the way. That's 1958. That's fairly recent.
right, the essential elements of due process of law are notice and the opportunity to defend.
Was I given
Okay.
an opportunity to defend? Was I given notice?
So okay, the right cannot be deprived without due process of law. Okay, so at whatever point you want to stand on your right, is that abstaining from a driver's license? Is it having a driver's license and then getting into court over something? Wherever you are, at whatever point, well, hey, excuse me, what about my rights? The essential elements of due process of law are notice and opportunity to defend. If you do not receive notice and opportunity to defend, this goes back to what WD was questioning, though. He's saying that he doesn't believe we were right because as sovereign we acted on our own accord and we initiated the driver's license application and blah and whatever. However, the code says I have to have a driver's license within 30 days of entering the state from some foreign jurisdiction or from the time I turn 16 or whatever. If I want to operate a motor vehicle, I have to have a driver's license. And because of that, I believe that that there is there is a case to be made that I did not initiate the request for application. The state did. Okay, we've got a question from Eric. Fundamental basis of the contract is the presumption of 14th Amendment citizenship and the Social Security number. The point of this is to hypothecate labor for backing private money system, Federal Reserve. This was in fact done without notice and is not per trust, but rather contract law. I get his point for sure. In 1913, the Federal Reserve Board changed the game. Eric says, true, but did not contract for hypothecating labor thereon. Okay, you can take just about any code argument back to 1913, followed up by 1933. The formation of the Federal Reserve Board and then the Federal Reserve Bank. And you can stand on that and,
Well, what you're talking about though is he's talking about Social Security, the Social Security Trust, and he's talking about the Social Security Act, and what he's talking about is being collateral for the debt of the public trust, as well as being a beneficiary of the privileges that are issued by the public trust. And that's all well and good. He's saying that's the fundamental basis by which law enforcement or other officers are inherently operating and stating that you have consented from the get-go, or in a way initiated the application just by the mere act that you already participate in a previous trust. And I think that could be argued, but I think that it's not the point of this series. We're going to get into some of that. We're going to talk about that as a concept, and we have to cover that because it has to do with a lot with recognizing and declaring that we had no consent, and that there may be a time where we may have to void a certain contract by that way. And I agree with you, and I think that is the foundational basis of expatriation and basic understanding of some of the concepts of quote-unquote sovereignty, so to speak. But it's not what we're going to be talking about here. We have to focus solely on the contract at hand, which is the license. And I believe that there is, to some extent, an initiation on our part by way of having that and already participating in it. I believe that all is based on tradition. And I believe that it falls under the legal maxim of he who fails to assert his rights has none. So just as Christian said, all of this may be so, but the right to travel is part of the liberty of which a citizen cannot be deprived without due process of law. And just having and participating in a federal contract or a public trust contract by which there's some sort of exchange, which you, by the way, are only claiming, there's no evidence truly that you would be able to state that there's an actual exchange of energy for a certain amount. There is only a contract that stipulates that we stand as collateral for the debt and that we do our best to pay that debt back. That's just a bond. So there may not be even a value involved. So it's hard to distinguish that. But in terms of the contract at hand, I don't believe that it avails me to any other contract. I believe that he who fails to assert his rights has none. And I was not availed of that contract from the get-go. There was no due process of law of that from the get-go, and I could stand on that, but in another venue, in another webinar, because it's a whole nother case.
And that is his point. He's saying that, and he writes in the note here, saying that we consented is only true as a layer upon non-consent.
And that's what I talked about from the start of this, is that, okay, well, my parents signed me up. Okay, well, that's the fact, is that I did not consent, but have I expressed that? Or have I just gone on living? It's the form of expression. It's what we know and what we can distinguish and where we can operate from that matters. And that is a major reason that we put this together. So your point is very well heard, and it's a major factor, I believe, in this. And I wish we could go on talking more about that specific topic. I don't know that it binds us primarily. I believe that it is an adhesion contract at one point, but I believe that it is a contract trust with which you can step out of. And we covered that in our last series, that once it's represented as a persona, it can be stepped out of, and your rights are never subrogated. They are unalienable.
Right. Flash forward to how we're going about this. This webinar is about how to stand on inalienable rights, meaning under the Constitution, right? That's what the homework was. And that's one way to do it. The other way that it might even be preferable is to operate as trustee of a private express trust outside of the jurisdiction of the federal forum, and thereby operate under unalienable rights. And for sake of simplicity, I guess, although none of it's terribly simple, we're going to present those. And Eric, you're absolutely right. I agree with, and it's a great point.
I
You'll get
agree.
no argument. You get no argument from me. You could easily, just as easily stand. Well, I don't know if you could just as easily. Actually, I take that back. You could stand on that, and you'd be right. Okay. I think there are at least two easier ways to go about traveling than trying to stand on that. And of course, the test of anything is how does it play in court, right? And I think there are two easier ways: either stand on the Constitution, or dismiss the case for lack of jurisdiction based on the fact that you're not operating in their jurisdiction. Let's go to WD. Thanks, Eric. WD says, as far as due process not being provided, I was only directing my comment toward the voluntary acquisition of the driver's license. It's voluntary in theory, and yet, everything seems to say in the code that it's not voluntary. The choice seems to be, if you read the California or any state's vehicle code, that if you want to do what you want to do, which is travel to grandma's house, you need to have a driver's license. You want to get to work, got to have a driver's license. Okay? You're 16, you want to get behind the wheel, you got to have a driver's license. And that colorable presentation of the facts is suspect to me. Yes, it's voluntary. The IRS does the same thing. Okay? It's a voluntary system. Okay? But try and see what happens if you don't correspond with them. All right? So it's a very, very colorable presentation of the facts, and what we want to do is not question that so much as operate in a way that handles that. Let's go to the next slide. Yeah. Okay. So this is in the intro to the brief. This is just excerpted from that intro, and I think it gives us a good launching point from which to discuss the case law that's in that brief. The forgotten legal maxim is that free people have a right to travel on the roads, which are provided by their servants for that purpose, using ordinary transportation of the day. Licensing cannot be required of free people, because taking on the restrictions of a license requires the surrender of a right. I'm going to read that again. That's why it's in bold. Licensing cannot be required of free people, because taking on the restriction of a license requires the surrender of a right. The driver's license can be required of people who use the highways for trade, commerce, or hire. That is, if they earn their living on the road, and if they use extraordinary machines on the roads. In other words, if you're not using the highways for profit, you cannot be required to have a driver's license. And this is by Bob Hardison, who I believe wrote the brief, although we attributed it to him. He didn't sign it, but we believe it's his, and I couldn't ask him because he's dead now. He was an old guy. But let's look at the brief. It was the homework we assigned, and it isn't original source material in the sense that we're not going straight to the cases or whatever, but it is a great survey of the case law that's out there, and it's not exhaustive either. There's more case law out there. You'll be getting some more actually in a couple days for the homework for the next one. But it's a great summary of the case law. He really wraps it up well, and my understanding, again, I couldn't ask him because he's dead, but my understanding is that this has been presented in multiple states and has been cause for dismissal of traffic violations.
All right, so we have U.S. Constitution, Amendment 5, Clause 7, Due Process Clause. Nor be deprived of any life, liberty, or property without due process of law.
And the follow-up Amendment 14, Section 1, Clause 3, Due Process Clause, nor shall any state deprive any person of life, liberty, or property without due process of law.
That's pretty
Okay?
clear. So here's our argument, and it introduces Justice Tolman. And it says here, if ever a judge understood the right of the public to use the public roads, it was Justice Tolman of the Supreme Court of the State of Washington. Justice Tolman stated, complete freedom of the highways is so old and well established a blessing that we have forgotten the days of the robber barons and toll roads. And yet, under an act like this, arbitrarily administered, the highways may be completely monopolized if, through lack of interest, as I was saying before, the people submit. Then they may look to see the most sacred of their liberties taken from them one by more or less rapid encroachment. And just again, through lack of interest, okay, we just give it back. The people submit by lack of interest. He who fails to assert his rights has none.
Personal liberty, or the right to enjoyment of life and liberty, is one of the fundamental or natural rights, which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from or dependent on the U.S. Constitution, which may not be submitted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the right to private property, and is regarded as inalienable.
It is constitutional law.
Okay, that's personal liberty. Now let's read the next one. Personal liberty largely consists of the right of locomotion, to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens.
That looks like the one we read earlier from Black's Law, 4th
Right.
edition.
Sure. The right of the citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but the common right which he has under his right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected, not only in his person, but in his safe conduct.
Dude, if it couldn't be rebutted, this should be all you need to dismiss any traffic case.
Right. Well, and the case law that goes with it. This is American jurisprudence, but yeah, absolutely. And the case law is there to go with it.
Right.
Okay. Let's go down to and further. Personal liberty consists of the power of locomotion. Okay. Of changing situations, of removing one's person to whatever place one's inclination may direct, without imprisonment or restraint, unless by due process of law.
Now that is Black's Law, 4th. It says here Bouvier's Law, 1914, and Black's 5th. We saw it in Black's 4th as that specific definition.
Yeah, Black's 4th is very similar, if not the same. And Blackstone's. Yeah.
Where rights secured by the Constitution are involved, there can be no rule making or legislation which would abrogate them. Let me read that again. Where rights secured by the Constitution are involved. So we're talking about rights secured by the Constitution, which we've already established in our last case law. There can be no rule making or legislation which would abrogate them. So
Miranda v. Arizona is an important one. And actually, so is the next one. But these are ones that come up a lot, and the reason is that they're overarching, right? This is not just talking about travel here. This is talking about your rights. If the Constitution upholds your rights as inalienable, then there no code can abrogate that right.
So the claim and exercise of a constitutional right cannot be converted into a crime. Miller v. U.S.
So standing on your rights cannot legally forget lawfully even, but legally cannot be converted to a crime.
Mhm, mhm. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. And that right there should be able to throw out any case in any court with any attorney that's going to attempt to try you. And any traffic infringement, there's not even going to be an attorney there. There's already a conflict of interest with the judge, because the judge is actually practicing law from the bench. But that
Well, there's the prosecutor there, and he's a bar member. There's gonna be the DA or whoever will be there.
Well, I don't know about you. When I go into a traffic case, there's rarely ever a prosecutor. The
Yes,
judge.
there is. He's sitting in the front row.
That's true. That's
He
true.
doesn't he doesn't have to get up because the judge just handles it all, but he's there.
That's true.
Yeah, he's there.
That would be the clerk.
No, no,
Who's the prosecutor?
there is somebody there. If there isn't, if what you're saying is true, then you can get the case dismissed right there for failure to appear. But there's somebody there for the state or whoever it is, that the city or the state or the county or whatever that's bringing the charges. There's somebody there. He may not stand up because the judge is just doing his rubber stamp thing, but there's somebody there. He's sitting. He's the guy sitting with a smug face in the front row.
That's interesting
Yep.
because I know there's a clerk of the court, but I've never
No,
seen.
no, no, no. He doesn't. No, no. It's not somebody who works for the court. It's somebody who. It's the prosecutor.
I
It's
understand. I
yeah.
understand. They're representing the state or
And he
representing,
does work. He does work for the court in a sense. He's a bar member, but
but they're representing the city. The
it's
cases
not
of
the
the
clerk.
city.
It's not the bailiff. It's not the judge. There's somebody else there representing the claimant. Yeah.
I agree. I agree. For while a citizen has the right to travel upon the public highways and to transport his property thereon, and that's again transport his property. We talked about the U.S. code that talked about the difference between transporting property and commercially transporting property. That right does not extend to the use of the highways either in whole or in part as a place for private gain. For the latter purpose, no person has a vested right to use the highways of the state, but is a privilege or a license which the legislature may grant or withhold at its discretion.
Using the highways for the purpose of making money is where the code originated, where it comes from, what it really applies to. And a citizen has the right to travel.
Well, this is a good thing to bring up right now. And I wanted to know if anyone else has an opinion, because what we're doing here is the interpretation of law is to each his own. It literally falls under contra pro forentum. So when you're in a position to interpret law to your advantage for a case, you and by the way, Brandon Adams is the first person to tell me this. He used to get court documents and cases and charges and things, and he would use the exact same law that the lawyers were citing and reinterpret it a different way and use it to validate his points. And it's a very simple way of understanding that law is interpreted in any way that you see fit, and it's going to be interpreted to the advantage of the individual using it and stating it in their in their declaration or whatever kind of, whether it's a pleading or anything of that nature. So
Yeah, some of the best ammunition you have in a court case is what the opposition provides to you.
I agree. I agree 100%, because when you go and you read those codes, you go, "Wait a minute, I see this as something
or,
different."
or,
And
or case law. It's
yeah,
even more
or
important.
case
It's
law.
like, oh, really? You gave me that case? I wonder why you gave me that. You're you stretching that much? Because here's how I see that. I'm going to tell the judge how I see that.
Yeah, and the judge may actually interpret it to see it the way you see it rather than the way the lawyer sees it, and may actually rule in your favor because of using the same case that he drudged up, which he'll feel like an ass about. But that's so. I guess what I'm saying here is that we really encourage over the rest of this series and the next three series, or the next three webinars of this series, that you engage in the same actions and that you bring up any questions that you might have, or that you bring up your own interpretation. For example, I see it as something different, and there's no wrong way to interpret this. We all have a right to argue it in a certain way. And some individuals may agree, some may not, but it may win or lose a case. And your ability to distinguish and interpret case law is really going to be a foundational and fundamental standpoint for you to operate, traveling or in any action, whether it's behind the wheel of a car or it's in a court, or it's operating in a certain jurisdiction, or it's commercial, it's non-commercial, it's going to be your interpretation of the situation, or your interpretation of the law that regulates that situation, that's going to be your advantage in that situation. So, okay, next.
Yeah, okay. I'm going to look at a few questions here because there are a number that will come in. You can leave that
Good.
up
So
for
you've got
next.
got a little rise with people. That's good.
Why don't we take a few more questions and then we'll go to another short break and then we'll come back.
Okay, cool.
So Selim asks, what is your take on traveling in a state licensed vehicle? Can one legitimately argue the right to travel and violate vehicle codes with a licensed, registered vehicle? If your objective is to violate vehicle codes, you're in the wrong place because that's not that's not what we're teaching here. Hypothetically, it says. Okay, so the point's well taken. I think we need to get into that in another session. We're going to be talking more about that, and we're going to get to that. So, okay, yeah, right. Selim says okay. The answer will, I think, come clear on that. Robert says, does prosecution have to be there during arraignment? Just to have to be there? Because I had said that they're always there. Selim says not always. I think the comment, I think that was where Selim's comment was directed, was, yeah, okay. So Selim says not always. My personal experience is if the accuser is not there, nothing moves forward. Okay? And I might stand on that to the extent that I want the client to be there too. Okay? But somebody's got to be there moving the court, or I'm out of there. I mean, that's it. Judge, to continue to dismiss it.
Well, the judge, just on merit, is often going to dismiss it. They're
Right.
going to give a default judgment.
Right. So it may be that you've been in court and there wasn't anyone there, but if that's ever the case again, you have a right to face your accuser. That is a right. Okay, it's not a privilege, and it is supported by the Constitution, and you're out of there, scot-free if your accuser's not there. Selim says, "Are you talking about the prosecutor or the cop?" Now, somebody's got to be there presenting or representing, right?
Well, in an action like that, normally an officer is the individual bringing an action. It's an interesting thing that you bring that up because I personally had a case dismissed. I was asked to post bail. I offered to place myself up in my own credit, and he waived bail. I knowingly didn't want to place bail because I knew that the infraction would probably be dismissed because the officer actually told me he probably wouldn't appear. And when the case started, he pulled a roll call, and if there wasn't a plaintiff in the matter there, or there wasn't a defendant in the matter there, you would rule it as a case that was a default judgment in favor of the individual that was there. It was a very immediate action. He didn't even have to, the plaintiff or defendant that appeared didn't even have to move the court. It just happened because it's a basis at law that there needs to be an individual bringing an action. And if that action isn't brought, the judge can't bring the action. So what we were talking about earlier, Christian, in arraignment, there may in fact be a prosecutor there, but at an actual court pleading, at a not guilty plea has been placed in, for example, this action, the individual that was bringing the action was the officer, but he was bringing the action under the city because he's a bonded officer of the city. So he's the witness and he's the actual individual that needs to bring the charge. And when that individual didn't show, I was immediately dismissed.
Well, you're talking about two different things. Okay, so first you've got somebody has to be there representing the state or the city or whatever it is. Okay, and then there's your witness, and the testimony, the ticket, okay, is worthless if you stand on your right to face your accuser. So if there's nobody there to support the declaration, which is the ticket, okay, then that evidence is worthless. So if you insist that you have questions for that officer and that officer is not there, then they're either going to continue it or throw it out. In most cases, with traffic stuff, they're going to throw it out. As you'll find, as you get into more serious matters, they don't just throw it out. They continue it to get that person there. But in traffic court, typically, if the cop doesn't show up and you insist that you have questions for the cop and you're not moving forward until you get these questions answered, they're just going to throw it out. Okay, so I have a list of questions all over the place here. Someone says, but they will assume you consent to the prosecution by the cop unless you object. Right. As far as I'm concerned, you can point out that the cop is not the state. And if there weren't a cop and a prosecutor there in my court, we wouldn't be moving forward at all. Eric says, State v. Johnson, quote, that was the last citation that we had up, is particularly relevant insofar as the commons being used for private profit. For example, when did the public allow private corporations to cut down its forests for a pittance? Socialization of costs, privatization of profits issue. So that is precisely why this makes perfect sense. I agree with you. Thanks. He says state authority would have to be derived from Constitution, per the PJ comment. He also says interpretation and construction are two sides of the same coin and must properly always be reconciled in context of higher authority. Agreed. Allen says, in any citation, all court cannot even pass a jurisdiction test, as all traffic court do not have jurisdiction over a live and living man or woman. Allen, I agree with you, and I don't know how many times you've tried to make that stick in court, but it's not easy. I have been in there, done that, and I can tell you it was heated. It resulted in a couple of sheriffs going down the elevator with me when I walked out of the courtroom because the judge was obstinate and would not, anyway. Yeah,
that's why we're talking about, we're going to talk about two different ways to handle that. We're going to talk about the inalienable and the unalienable. Right.
You're not wrong. You're not wrong. And at the same time, it's a very tough position to stand on in court.
Yeah, it's very quasi confrontational because you're standing in the jurisdiction. And granted, the state and federal rules of civil procedure all grant, without actually granting jurisdiction, allow you to place in a dismissal. But have you actually placed in that proper dismissal? It's a demur, something of that nature, you may not have, and it has to be on a specific response. And it's not, I'm a living man. It's definitely not that. So there's specific rules that you're playing with, and knowing those rules doesn't necessarily mean that you're privy to those jurisdictions, but it will allow you to operate around those jurisdictions and recognize when you are availed to them and when you are not, and when you have an opportunity to appear specially and place in a special form of dismissal or a petition or a notice of dismissal rather than a request or a motion.
Through the course of this series, we're going to bring it around to how to best handle the matter privately, or as a private individual, as trustee of a private trust. I mean, that's really why we do things the way we do them. Having been down the road that you're talking about, I've tried it. Alan says when jurisdiction is challenged, the court must prove jurisdiction. Okay.
You're also asking that court to do that too, and we're not talking under paper. You may be 100% right, but it's
not the way it works in traffic court. I guarantee you.
Other things, yeah.
It's not even the way it works when there's $1 million at stake in foreclosure or whatever. It's not. It's just not. They don't prove jurisdiction. They make you prove them wrong.
Yeah, the prosecutor will still call you. The prosecutor still call you an idiot, and then ask when him and the judge are going to lunch. These are things that actually happen.
Right,
you know
right,
I mean?
Right. If you have that much faith in the legal system, the first thing I would suggest that you might want to do is figure out a better way to operate, because that faith in the legal system will fail you.
And it's not. I wouldn't even say that. I would just say that we're giving the kind of information that is necessary to build a foundation that allows you to stand on that constitutionally and under natural common law right.
This is from WD. Your private interpretation of the terms used in public law is only valid in a public forum if you have public agreement as to what the terms you are using mean.
Definitely, definitely. And I think that is one of the main reasons that we're using relevant and intellectual sources that are well established and well recognized at law. And
F
our interpretation is left up to argument, by the way. I mean, you have a prosecutor that'll come in and call you an idiot. There's nothing at law about that. So I think that what you're saying is true, but I think that there's a demeanor that takes place that is a distinction as well.
He says, as far as trying to redefine the term private gain as being a private matter, the whole concept of being able to require drivers and vehicles to be licensed is based on using public roads and highways, not private roads, for some person's private or personal gain instead of for the public's gain.
Well, we covered a little bit about that, right? We covered that in our last series, talking about where the public derives its power from as a service, and what we pledge as creating that as a form of public. And we just talked about the state not being able to subrogate that power, and that was kind of a point I was making with this last one that I talked about with private gain. But I agree with you to some extent.
Well, I agree with him completely. The thing is, language. Did I mention this before? Language is a means of control,
And it's
and
deceptive as hell.
and language can be very, very colorable. And the English language has a whole subsection of it called legalese. That is the language of the code. And how you define everything in a sentence changes the meaning of the sentence completely. So
I also
we're
have a point to make too, and that's that, when you're placing in a pleading or a declaration or an affidavit, it stands as truth unless it stands unrebutted. And the support of that affidavit, if standing on founded case law, is the key to winning a case publicly, period, regardless of the situation. And that's something that we are covering right now.
I'm going to just wrap up with WD's follow up here, and then I suggest that we take another short break and come back and finish up. WD says you guys are doing a great job, and with a subject that spans concepts that can be hard for a lot of newcomers to understand. Thank you, WD. Thank you very much. He's a brand new member, and we appreciate your comments.
Yeah,
Uh,
thank you so much for what you've said and for supporting us. We
and,
really
and and for your great commentary. It's welcome, brother. Your questions and comments are right on point.
I'm so glad that we just appreciate all of you. So let's go ahead and go to break. This has just been a great conversation topic. For those of you that have more things to say, please don't hesitate when we get back to raise your hands. And we have time, and we have a little more case law we can go over, and we'll move smoothly, and we'll have some good conversation and some great topics, and hopefully we'll get out some great interpretations of some ancient case laws.
Another 5 minutes. Once again, it's musical chairs. Be back in your seat when the music ends. We'll see you there.
Thank you.